Thank you. And before we get into conservatorships and alternatives, we're going to tell you about our backgrounds and our organization. So I will turn things over to Stephanie.
Hi, everyone. Good morning. Thank you for joining us on a Saturday. As Shannon said, my name is Stephanie Kroll-Vieira. I am the Clients' Rights Advocate, or CRA, for the San Andreas Regional Center. Prior to my time at OCRA, I've worked at a few other legal organizations in the Bay Area, and I specialize so far in benefit advocacy, youth justice issues, and homelessness prevention. So I will also give a brief intro of OCRA. We are a program within Disability Rights California, which is California's nonprofit agency that is dedicated to protect and advocate for people with disabilities. Disability Rights California is the largest disability rights organization in the United States, and we have nearly 300 employees engaged in all different types of disability rights advocacy, community engagement, and disability justice. So now I'll turn over to Shannon.
Thank you, Stephanie. Yes, my name is Shannon Kogan. I am the director of the Office of Clients' Rights Advocacy. I'm also a parent. One of my children has developmental and learning disabilities. I used to be a trial lawyer in the Bay Area, and advocating for my child changed my career path. We had a lot of problems with the school district, and I used my legal training to help my child. So when things got simpler for my family, I joined Disability Rights California in the Office of Clients' Rights Advocacy, which we call OCRA. We have a link up on the screen that'll be in your slides, a link to our website and to Disability Rights California's general website. I used to be in the same job that Stephanie has now, the Clients' Rights Advocate for people who are served by the San Andreas Regional Center. In my disability rights work, I advocate to avoid conservatorship when possible in favor of alternatives that help people build their independence and decision-making skills. But I used to be an attorney for the County of Santa Clara, and I represented the public guardian in conservatorship cases. When I did that work, it was mostly involving elders, people who were being financially abused by their relatives and caregivers and needed some protection from the people who were closest to them, unfortunately. So I come at conservatorship from two different perspectives. I hope that we give you good information in this presentation this morning. If you have questions, our contact information is on the last slide of the presentation, and you can always reach out to us directly.
Okay, so as I just stated, the Office of Clients' Rights Advocacy, also known as OCRA, is a program contained within the larger organization of Disability Rights California. OCRA is funded by the California Department of Developmental Disabilities. And Disability Rights California is the nonprofit organization designated under the law to protect and advocate for the right of those with in Californians with disabilities. Chat popping up, so I'll ignore that. So OCRA advocates on behalf of people who are clients of the regional center throughout the state. And while we work closely with the regional center, just as a reminder, we are a separate legal organization contained within Disability Rights California. And so we do not work for the regional center. Our local regional center, the San Andreas Regional Center, covers the counties Santa Clara, San Benito, Monterey, and Santa Cruz counties. And now OCRA can work with clients who currently receive regional center services or those who are seeking eligibility to receive regional center services. Apologies, I'm about to sneeze. And people are eligible for regional center services if they have a developmental disability that started before the age 18, and that constitutes a substantial disability. Go to the next next slide. Sorry about that. Okay, so oops. Each OCRA office has a CRA and an assistant CRA or an assistant client's rights advocate who are trained to specifically work with individuals with developmental disabilities. OCRA can assist on several areas of law, including but not limited to the following areas, which include regional center services, special education advocacy, Social Security advocacy, Medi-Cal or private insurance issues, discrimination, personal autonomy, community integration, IHSS, abuse and neglect. And the list can go on depending on the circumstances. OCRA offers different levels of services depending on the merits of the case and the ability of yourself and your family to advocate for the client. And the availability of OCRA resources, but we may be able to provide you with information and referrals, review documents, provide information and advice on how to proceed with legal issues, or prepare you for upcoming meetings, depending on the circumstances. And OCRA, we really do evaluate each case individually before we determine if we can represent. And just a brief disclaimer before we start our presentation today. As mentioned at the very beginning, we welcome questions through the Q&A function. However, please do not include any information that is private or confidential.
Sorry, could you say this again?
Sorry, don't know why that happened. So again, please do not include any private or confidential information in your chat about your family, your friends, or anyone with the disabilities. We are mandated reporters and have to report any suspected abuse or neglect of disabled adults. And finally, while we are providing information about alternatives to conservatorships, we are not providing private legal consultations today. So no attorney-client relationship is formed in this presentation. My office's direct contact information will be contained in the last few slides. And if you would like to discuss with us further about alternatives to conservatorships or other issues for a person served by the Regional Center, please give us a call and myself or the ACRA, Maria, will follow up next week.
All right, thanks so much, Stephanie. I'm showing our slide with the agenda. We're going to give you an overview of conservatorships to help you understand what they are and what they mean. And we'll give an overview of alternatives to conservatorships. I do want to let you know what we are not going to do today, which is we are not going to give advice on how to conserve someone. Disability Rights California does not give legal advice about obtaining conservatorships. There are attorneys who do that work. They are usually called probate or estate planning attorneys. So this is our slide about conservatorship, the general function. So a conservatorship is when the court appoints someone to make decisions for another person. And the someone who is appointed could be another person. It could be multiple people, or it could be an organization or an entity. So people who are conservators are sometimes family members, sometimes the public guardian, sometimes the Department of Developmental Services, which we call DDS. When regional centers do not, when regional center clients don't have another appropriate person to assist them, sometimes the department does that. There can also be private fiduciaries, trustees, who serve as conservators. That is much more common with a probate conservatorship for someone who has a lot of money. It is much less common for people who depend on public benefits. So a conservatorship takes fundamental rights away from someone. So our fundamental rights are things like life, liberty, the pursuit of happiness. It's a serious thing and it's a big deal. And a conservatorship is supposed to be the exception, not the rule. Conservatorships apply to people over the age of 18. There is an exception There's a mental health conservatorship for children under the age of 18, but that's pretty rare, and we're not going to discuss the specifics of that today. So in general, you just need to know that conservatorship is for adults. And a conservatorship lasts until either the court terminates it, so issues an order saying there doesn't need to be a conservatorship anymore, or there's some other event. Those events are things like death, primarily. And I want to give you a little bit of language to use. We might use the words conservatee and conservator. The conservatee is the person with the disability who's being conserved. The conservator is the person who the court appoints to make decisions for them. I want to talk about different types of conservatorship. And I also want to let you know that conservatorship law is state specific. If you hear something from another state, it is probably different than the system we have in California. We have a very different system than most other states. I also want to tell you that in other states, what we call conservatorship is usually called guardianship, which can be confusing because we have something called guardianship in California, but it's for children. When a child needs someone, their parents aren't available, the court can appoint a guardian. But in California, that's only for children, and adults are for conservatorship. So there are 3 different types. The limited conservatorship is when the court appoints someone to make decisions in specific limited areas. They're only for people with developmental disabilities who are regional center clients. People with developmental disabilities can make many decisions on their own or with support. And under the law, the court only appoints someone to make decisions in the areas where they can't do it. Limited conservatorships are supposed to make sure that the conservatee is as independent as possible and retains as many rights as possible. Another type of conservatorship is called the probate code, the probate conservatorship. It's also where the judge appoints a conservator to care for an adult who can't take care of themselves. It's typically used when people are aging or experiencing dementia. There are 2 types of conservators in a probate conservatorship. You can have a conservator of the person. That person cares for and protects the person in terms of personal care decisions. You can also have a conservator of the estate, and that person handles financial matters like paying bills, collecting their income when the judge decides someone can't do it. So again, probate conservatorships are typically for people whose capacity changes over the course of their life, like if we're getting older or have a sudden injury of some kind. I will say you're probably all familiar with Britney Spears and the Britney Spears conservatorship situation we've seen in the media over the last year. She was actually subjected to a probate code conservatorship, which is a little unusual. The 3rd type of conservatorship is called an LPS conservatorship. It's named after the lawmakers who made the law. It's for mental health conservatorships. It makes the conservator responsible for an adult with a mental illness. LPS conservatorships are started by a local government, usually a public guardian. They're limited to 1 year. And after that, if they're still necessary, then you have to repetition the court for it. Those conservatorships are only for adults who are gravely disabled as a result of mental illness. So common diagnoses for someone on an LPS conservatorship would be something like schizophrenia, bipolar disorder, clinical depression. And the standard to be gravely disabled is very high. So those are the general types of conservatorships. Because our focus is on people who receive regional center services, most of our discussion and information is about the limited conservatorship process. We can probably go quickly over this slide. It'll be in the deck for you to refer back to. But I already noted guardianship is for children, conservatorship is for adults, so we don't have to spend a lot of time on this one. So this slide is about capacity, which is about sort of the heart of conservatorship. So when you have a conservatorship, it's because there's a belief that a person with a disability does not have the capacity to make their own decisions. So capacity is the legal word. Another word for capacity is ability. And the law actually says that everybody has the ability to make decisions and be responsible for their acts and their decisions. I put a quote on the slide so that you know that's language from the law. It's from the probate code. The law also says that a person with a disability might still be capable of doing things like contracting, marrying, making medical decisions, and other large decisions like that. Merely having a diagnosis of a disability is not enough for a court to make a determination that someone lacks the ability to make decisions or lacks what's called legal mental capacity. I want to talk about the process a little bit. So as it's set out on the slide, right, the petitioner, that's the person who wants to be the conservator, they file a petition with the court. They take some paper, they fill it out, and they send it to the court. They also have to send copies of it to the person who's called the respondent. That's the person they would like to conserve. They also have to send it to some relatives of the person and different agencies. That includes the regional center for limited conservatorships, because the regional center will be asked to write a report to the court. The regional center will assess the person and tell the court about their disability, what kind of help they need, their physical condition, their mental condition, and they make recommendations to the court about the specific rights that the proposed conservator is asking for. There's also someone in the process called the court investigator. That's someone who's employed by the court, works in the probate department usually. They explain the petition to the proposed conservatee and they interview them. They tell them about the conservatorship process. They ask them if they want to attend the hearing, if they're able to attend the hearing. They find out if they want to be conserved or not, if they object to the conservator, if they prefer someone else. And then at the end of that process, the court conducts a hearing into the petition to determine if the person should be conserved. I'm going to take a break and look at some of the questions in the chat. Okay, so I see lots of questions about what kind of rights there are and powers of attorney, and I'm glad you're asking those. And those are questions that we get to later on in the presentation. So hopefully we'll answer those questions, and if not, we'll circle back to them. So more about the conservatorship process. The person who's the proposed conservatee has rights. They have the right to notice. That means they get to know about the court proceeding, and there are specific deadlines for that. They have the right to oppose or object, to say, I don't want to be conserved, or I don't want to be conserved by that person. They have the right to be present. They have the right to a jury trial. It's very unusual, but they have a right to have a jury decide whether they should be conserved or not. And they have the right to call witnesses at any hearing or trial to support their position. Once someone's conserved, it's actually really hard to end conservatorship. We set out on the slide the different things that can end different kinds of conservatorships. With a general conservatorship, it doesn't terminate if the conservator dies. There's still a conservatorship and the court appoints a new conservator. With a limited conservatorship, so people who are regional center clients, if the conservator dies, the conservatorship also ends. Other ways to end a conservatorship is by asking the court to end it, to say, I don't need someone to make these decisions for me. Someone needs to show that they're able to care for their health and food, clothing, shelter, finances. And they can prove that by showing that they use supports and services and alternatives, which are things that we'll discuss a little bit later in the presentation. But it is really difficult to terminate a conservatorship once it's been initiated. So some of the rights that people retain, even if they're conserved in a limited conservatorship, people retain the right to control their own salary. So if they have a job and they have money coming in, their conservator does not have the right to receive their salary or determine how they spend it. You retain the right to make a will, to say who's going to get your personal items when you die, to get your own mail, to be represented by an attorney. You can ask for a new conservator. You can ask to end a conservatorship. You also retain the right to vote, but the court can restrict that right and say that this person doesn't have the capacity to make that decision. Voting is a fundamental right of citizenship, so it is supposed to be something that the court considers very carefully. Things that a conservator cannot do in a limited conservatorship, they cannot approve harmful medical treatment or agree to electroconvulsive shock therapy. They can't force medication therapy on the conservatee. They can't have the person sterilized or committed to live in an institution. They can't force the person to participate in psychotherapy. And they don't have any power that's not specifically ordered by the court. So what powers does a conservator have? These are the 7 powers in a limited conservatorship. Things like determining where someone lives, having access to their confidential records. So those are things like medical records, educational records, financial records, controlling their right to marry, controlling their right to contract. So contract can mean anything like opening a credit card, having cell phone service, a service plan. They also can have the right to consent to medical treatment, which is different than forcing medical treatment on someone. The right to control social and sexual contacts and relationships. So to say, you can't be friends with that person, you can't have that boyfriend or girlfriend. And then to make education decisions. So each of these are separate powers that the court should evaluate individually in a limited conservatorship to determine if the person can make decisions on their own or needs someone else to make those decisions. We have a few slides, the next, I think, 5 slides that have some myths that we've heard from people who call our office, from clients and from their families. A lot of this information comes from the systems that we interact with, right? We interact with doctors and schools and all kinds of different systems that might not have great information. So this first myth is that conserving your adult child is the only way you can stay involved. And we'll talk about alternatives later, but there are a lot of less restrictive ways that a parent can remain involved in their adult child's life. So things like powers of attorney, things like supported decision making. Our next myth that we see is that if you don't get a conservatorship, you can't go to your adult child's IEP meetings anymore. So a lot of our clients are in the school system till the age of 22, and sometimes hear from teachers, from school systems, you have to conserve them once they turn 18 or you can't be involved anymore. So, the reality is that someone with a disability, just like someone without a disability, once they become an adult, they can choose to invite anyone to their IEP meeting, and that includes their parents. It also includes their friends, their advocates, whoever they might want to have support with in making educational decisions. But there's no rule that once someone turns 18, if they're not conserved, their parents can't be involved in their school system anymore. This is a similar myth that you lose all say in educational decision making once your adult child turns 18. So it is true that under the law, an adult has authority over their own decisions, but if their adult child wants their help in making those decisions, parents can remain involved by signing a form. It's called an assignment of educational decision-making form, and it gives their parents permission to make different decisions about their education. They may say, I just want help. They might say, I want my parents to make every decision for me. Or they might say, I'd like help figuring out this thing, but not this other thing. So there are ways to stay involved and to share decision-making that don't involve the court's involvement. This is a big myth that conserving your adult child is the only way to keep them safe. And people are usually more familiar with things like restraining orders. So someone who is in a domestic violence situation might get a restraining order. And I think we all know from media that restraining orders don't really stop people from physically harm you, right? The court order is not a magical shield. It's the same with conservatorship. Conservatorship is a court order, but it doesn't offer extra protection against being taken advantage of financially or physically or sexually. And if the person with a disability, for example, is arrested themselves, the fact that they're conserved doesn't give them any extra legal protection. So it's really not a protective mechanism to keep someone safe. The thing that helps keep people safe is building their own skills.
Hi, Shannon. Just if you could go back and repeat that slide. And it sounds like a couple other folks have had a little audio difficulty with you on that particular slide.
This one?
Yes, that last one. Yeah, thank you.
Okay, sorry. So the point of this slide is that conserving your adult child doesn't keep them any safer from financial abuse or physical or sexual abuse than not being conserved. It's a court order, and there may eventually be consequences for someone who doesn't have their best interests in mind, but like a restraining order doesn't stop someone from assaulting someone else. A conservatorship can be too protective. It can stop people from developing the independent skills they need to protect themselves from abuse. Was that better? Okay. And then one last myth is that parents who have already started the process of a conservatorship can't stop it. And that's not true. The conservatorship is created at a hearing. So even if you filed paperwork with the court, if the hearing has not happened yet, you can stop the process. You can just tell the court you're withdrawing the petition. You have the option to not show up to a hearing. In a very rare circumstance, a court might insist that you go through with a scheduled hearing, but you can ask for support, stating the conservatorship isn't necessary. You can ask the regional center to weigh in on it. You can tell the court that you want to practice supported decision making or other alternatives to support your adult child instead of pursuing the conservatorship. Okay, so these are the start of our discussion about alternatives to conservatorship. I want to talk a little bit about why we have alternatives. Conservatorship is supposed to be the exception. And that's because people have civil rights. Everyone has civil rights, whether you have a disability or you do not have a disability. And in a conservatorship, the court is taking away someone's civil rights and basically giving them to someone else. So, people with disabilities have the right to live independent lives, self-directed lives, and be active members in their community. And what that looks like will be different for different people. Some people have very significant support needs and will have those their entire lives. But retaining and exercising their own civil rights protects them in the ways that a conservatorship cannot. So as I mentioned on the previous slide, conservatorships are not protective. It's an illusion. And when your adult child was a kid, you probably made all their decisions for them. But when your child is an adult, they are entitled to make their own decisions if they can, regardless of disability. And sometimes parents are told the best way to protect our loved ones is to get a conservatorship. We are told that by respected professionals who we work with, by doctors, by regional centers, by teachers. But a conservatorship doesn't offer a guarantee that someone won't be taken advantage of. What does protect against that is developing independent decision-making skills, and you can develop those skills with alternatives. One of the other reasons that we like alternatives is that conservatorships can have unintended consequences. Things can happen that you did not expect to happen. So if you sort of turn over this control to a court, you might have a situation where a parent is a perfectly wonderful conservator, respectful, and respects their child's expressed interests and wishes. And then when that parent dies, the conservatorship ends, and that conservatee may not have had the chance to learn and practice independence and decision-making for themselves. So in that circumstance, sometimes a public guardian or a regional center becomes the person's conservator, which means that their major life decisions are being made by strangers who don't have to take their expressed interests into account. And so I would ask if that's a good outcome for that person. It usually is not a good outcome. It can also be very expensive. There are a lot of attorney's fees. And in California, the law requires the court to consider less restrictive alternatives before starting a conservatorship. So the judge should ask, what else have you tried? Have you tried supported decision-making? Have you tried joint bank accounts or money management classes? And if the person seeking the conservatorship has not tried those things, the judge should deny the conservatorship. It should only exist if those options have been tried in good faith and they really don't work. But in reality, conservatorships are often imposed when other supports and alternatives might work but have been tried. So one of the first alternatives to a conservatorship is called supported decision-making. And that's when you use people you trust to help you understand situations and choices. So it's a way to increase independence and to give you the power to make decisions about your life as much as possible. Supported decision-making is really how most of us make decisions. We reach out to people we trust. It might be a doctor or a mechanic or a friend to help us make decisions about things we don't understand. And when people without disabilities do that, we're considered very smart and wise. And so, in my family, my husband certainly makes every decision about our automobiles because I don't know anything about them. It wouldn't be good for me to make those decisions. So he makes those decisions for us as a couple, but in that in that process, he's engaging in supported decision-making for me. He's explaining to me why we might want to get a new car, not get a new car, what's the difference in the gas mileage in the engine, etc. And so when I reach out to him, who I trust to help make decisions about things like that, that's what people do. And those options should be available to people with disabilities as well, right? People with disabilities might need support, but it doesn't mean that they don't have interests and preferences and the human right to express them. So the quote that's on the slide defines what supported decision-making is. It's basically, it can just be relationships, very informal, or it can be very formal with written agreements to help someone make decisions and communicate to other people about decisions in their life. So that looks very different for everyone. It might be that you have a chosen, trained partner who listens and facilitates communication, if communication is a challenge that you have. It might be that you need extra time to discuss your choices, for example, in a medical environment, that someone will support you to not be rushed through making decisions about things. It might be someone who helps you make lists of pros and cons, or who role plays activities with you to help you understand how something is going to happen and what it might look like. It can be supporters attending your appointments to take notes and help you discuss options. Supported decision-making can also be things like talking about having a joint bank account and other ways to manage financial decisions together without giving up all control over your financial decision-making. So this slide has a link to a handbook that I think is really useful. Many of you might be familiar with Disability Voices United. They're a statewide organization, and they advocate for choice and control and accountability and good outcomes for people with developmental disabilities. And they created this supported decision-making handbook. It's really designed for parents, and it has information and material about reasons to avoid a conservatorship, reasons to use supported decision-making. It has examples that show you how supported decision-making can work in different contexts. It has specific advice for supporting people who are not verbal or who use augmentative and alternate communication. So that's any way to communicate other than talking. Could be a device, could be pictures, could be physical gestures. The handbook also has forms in it to help you support your adult child in different contexts, like in a doctor's office or in an IEP meeting. And it has some resources in it to move forward in supported decision making. So I really encourage you all to take a look at the handbook. It was really well done, and I think it has a lot of good resources. To talk about alternatives for each of the different powers of a limited conservatorship. So if you're thinking about conserving someone for a specific reason, these are some alternatives in different areas. So this is about educational decision-making. As I've said, it's really common for school personnel to recommend conservatorship to parents of 17-year-olds with disabilities. And so there is a form that's the transfer of educational decision-making authority form, where someone who is becoming an adult can sign it and say, I still want my parents to make these decisions, or I still want my parents to be involved in this process. If the student doesn't have the capacity to sign a contract, or prefers not to use that option, you could create a supported decision-making arrangement where the parent or whoever it might be assists in making the decisions. So that would be if a student has not been determined by a court to lack capacity but really doesn't have enough capacity to be informed and provide consent to their educational program. So it's still possible to do that without involving the court. Another option is a durable power of attorney, or the IPP process through the regional center. So you can execute a durable power of attorney. It's a document to say that you want to assign your authority or you want to share your authority. You also have the right to invite whoever you want to IEP meetings and IPP meetings. You can invite people who will support you in advocating for the services you need to be independent. So it can be your family, it can be other people in your circle of support. It could be a trained advocate like us from OCRA. So someone who has an IPP document with the regional center can ask for that document to set out any alternatives that you have for educational decision-making. And then the regional center's service coordinator can communicate that to the school with your permission. The second slide is also about educational decisions. I won't go too much into detail because it's really for educators, but the first link on the site that the federal government issued, and it recognizes alternatives to conservatorship, including supported decision-making, and it encourages school districts to help parents and students understand their options instead of advising them to get a conservatorship. And then, of course, that second link is for parents helping parents. The federal government funds the parent training and information centers to work with families and youth with disabilities and to help parents partner with other professionals like schools. So Parents Helping Parents is the parent training and information center for the counties that are served by the San Andreas Regional Center and also San Mateo County as well. So we put a link to their website because they also have people who can give you advice and good recommendations on educational decision making. So if you remember back, one of the other limited conservatorship powers is the access to confidential records. So some alternatives to that, again, a durable power of attorney, right? It's a legal document where someone can say, I'm giving this other person the power to make decisions for me. I put a link, a note in there, probate code section 4400. That's the law that says what needs to be in a durable power of attorney in order to make it effective. So power of attorney is a way to get help with services and supports to live independently. It can give someone the right to make one kind of a decision like financial or medical. It can give them the right to make both kinds of decisions. It's really up to the person who's delegating their authority. I'm going to take a pause for a second. Okay. I see that my audio is a little bit choppy. I'm sorry, I'm not sure what to do about that. I'll try to speak up. Another alternative for access to confidential records is to just sign a consent form for release of information. We have those forms at OCRA. You can say, hey, regional center, I want you to let my parents have access to my records. And you can sign that and give it to the regional center. And then the regional center knows they can always give copies of records to parents. So written consents can always be retracted if someone changes their mind later, but it's a good way to avoid the whole court process. Similar is a HIPAA release for medical records. We do those when we go to doctors all the time, right? We go see a new doctor and they say, oh, we need you to sign this release to let us tell your spouse about your medical situation. You can use those as a person with a disability as well to let other people have access to your records. Another alternative is something called supported contact. So that's might just be a three-way phone call. Instead of the person with the disability having to call Social Security independently, they can have someone else on the line and you can give your permission over the phone to say, I have my parent on the phone with me. I want you to tell them everything you would tell me. And you can do that with all kinds of different agencies who might be asking for permission to access confidential records. The next power in a limited conservatorship is the right to contract. Again, a power of attorney is a way to avoid needing a conservatorship. It's a legal document. So controlling the right to contract is most concerning in financial matters, right? Things like buying a car, opening a credit card, buying a cell phone and adding a service plan. I think we all worry about our kids, no matter how old they are, getting taken advantage in some of these ways. So people can sign the power of attorney for finances. It does have to be notarized if it's a financial power of attorney. It can be ended whenever the person wants. And with a power of attorney, you can also continue to make your own legal and financial decisions. So whoever you say has your power of attorney is your representative, but they're not your boss, right? You can give however many powers you want. And really, it should only be someone who you fully trust. So, it may be a family member or a very good friend. If the person with the disability receives Social Security benefits, there can be a representative payee for Social Security. That person is appointed by the Social Security Administration, and their job is to help a person manage their benefits. So the main responsibility is to help them pay for their current and future needs. Those are things like food and shelter and medical care. The representative payee can also help save any leftover money, and they have to keep a record of expenses, and they can't charge for their services unless the Social Security Administration approves it. There are organizational representative payees who represent a lot of people, as opposed to maybe a parent who would only have one person. Another alternative is to have services written into your individual program plan with the regional center. You can have services written in to help you manage money, and it might be something like an independent living services worker who helps, balance the checkbook, those sorts of things. Another financial alternative is a special needs trust, and then a trustee would then manage money. So estate planning attorneys can help set up special needs trusts. It is cheaper to pay for a special needs trust to be set up than to petition for conservatorship generally. And a trustee could be a parent, or it could be someone else. You can also just have the very low tech way of having a joint bank account, right? You can set up a joint account with someone you trust to help you make deposits and withdraw money. And that's a very low tech way that doesn't require a bunch of legal documentation. One last alternative for finances is the ABLE account. We have the link on the slide there to the CalABLE website. That's the California ABLE account website. So an ABLE account is a savings and investment plan for people with disabilities. Right now, you can contribute up to $16,000 a year without affecting the person's public disability benefits. And then people who have jobs can also contribute more money above the $16,000 limit. And the amount of that extra contribution can change every year. So last year it was about $12,000 extra. I'm not sure what it is this year. If you receive SSI benefits from Social Security, you can save as much as $100,000 in a CalABLE account with no effect on your federal or state benefits. Once you hit $100,000, your SSI would be suspended, and your eligibility for California benefits programs could be affected as well. So that's something to know. But the earnings in a CalABLE account are tax-free, both federally and in California. And if you make a withdrawal for a qualified expense, so something related to the person's disability, that's also tax-free. People with CalAble accounts are protected from creditors and from repayment of medical assistance. So it never affects your Medicaid or your Medi-Cal eligibility. And there are a lot of benefits to establishing a CalAble account. So we have the link there. That's not something that we give specific advice on because we're not financial professionals, but the CalAble website has a lot of information, and they also do frequent webinars to explain how the program works and what the benefits are, particularly for people on public benefits. Okay, and now we're turning to medical treatment. So I want to talk about this first line first. It says educate healthcare providers. Can the person consent to some healthcare services? So education is so important. I know an adult man with cerebral palsy, and he has very high support needs. He uses a wheelchair. He is non-speaking, so he uses an AAC device, that's augmentative and alternative communication. He has used many of those devices throughout his life, and they've changed as his needs have changed and as the vocabulary he knows has changed. He actually first learned to type with his toes on a manual typewriter when he was in elementary school. He has a lot of different medical providers, but he always makes his own medical decisions. And the way that he does that in a system that really is not set up to have a lot of patience with people who need something outside the norm is that he makes sure his medical provider know that he communicates with a device and by email. And he types up and prints out his concerns before every appointment. That reduces communication errors. And when he needs a referral to a different provider, he makes sure that his doctors tell that provider that he's capable of listening, he's capable of conversing and understanding. He just needs more time to do it, so that his appointments need to be scheduled for a longer period of time so he doesn't get rushed along. I think it's a great model for educating, and I know that it's difficult. Our medical system has a lot of drawbacks if you need more or different, if you need more time. But building a consistent relationship with one provider who can help be your advocate with other providers can really help. Another option for medical treatment is that just your closest relation can authorize healthcare in most cases. If you're the patient, the doctor has to tell you about the risks, benefits of a treatment, and what other treatments there might be, and what happens if you don't get any treatment. And if you're not able to make a decision, your closest relative available, like your parent or your sibling, can authorize healthcare if you're not objecting to it. And then the last alternative here is the durable power of attorney for healthcare. That's a separate form than a durable power of attorney for financial decisions. And it allows you to appoint another person to make physical and mental healthcare decisions on your behalf. It does require that you have the capacity to contract at the time that you enter into it. So if someone doesn't have the ability to really understand the consequences of entering into a contract, their durable power of attorney wouldn't be valid. And I put a couple other requirements there on the slide. You have to have 2 witnesses, or it has to be notarized. We at Disability Rights California don't give out the durable power of healthcare form to parents. We would meet with adult clients, and if they want us to do that and to work with their parents, then we would do that with their permission. Other alternatives for medical treatment, sometimes people don't know about this, but the regional center can actually authorize medical, surgical, or dental care for someone who is receiving regional center services. That would be when there's no other person who's legally responsible and the person involved doesn't have the capacity to consent. Then the regional center's or executive director under the law can authorize that care. Doctors or dentists can also make decisions in an emergency. That's in the Business and Professions Code for emergency medical procedures. It's not that if your loved one ended up in the emergency room and couldn't communicate their choice and you weren't there to do anything, that nothing would happen if it was an emergency. A doctor is allowed to make that decision. You can also get court authorization for specific operations. There's a whole process where the court can determine if someone has the capacity to make a healthcare decision. It's not for people who have conservators, it's a separate process. And then that last point says facility requirements to authorize medical interventions. So this is when someone lives in a facility like a skilled nursing facility. If someone without capacity lives in a skilled nursing facility and they don't have anyone else with authority to make their healthcare decisions, so they don't have a close relative, they haven't executed a durable power of attorney for healthcare, the doctor in the facility can't just make the decisions for them. If they want to do something that requires informed consent, then they have to assemble a team that includes a patient representative from somewhere else, not from the facility. And the team reviews the proposed treatment and makes findings about it. So in cases when people don't have a circle of support in the world of medical treatment, there are all kinds of alternatives that both respect the person's autonomy, but also, ensure that in the absence of a decision maker, they are still able to receive treatment. This next slide talks about just different resources on medical treatment. The first link from the Office of Developmental Primary Care at the University of California, San Francisco. This program was developed to build the healthcare system's capacity to serve adults with developmental disabilities. And they have all kinds of resources for improving medical outcomes. So these links are to support decision-making information and tools in the medical context, and also advice for organizing your records and keeping control of your meetings with medical professionals. And those are recommendations that come from people with disabilities and from their caregivers. And then the second link for the California Coalition for Compassionate Care. That's an organization that's not specifically focused on developmental disabilities. It's focused on high quality care for people who are seriously ill or nearing the end of their life. But they have a great paper on supported decision-making in healthcare, and it comes with a workbook and a video, and it's designed for regional center clients. So it's tailored to end-of-life decision-making, but you can use the process for all kinds of decision-making. It's a really helpful resource. All right, these are some of the tricky things, marriage and social and sexual relationships. So in a conservatorship, marriage is a little simpler to control because it's basically a contract, right? But I have never seen a conservatorship order that can actually control someone's choice of friends or their sexuality.
Shannon, if you want to just pause for a second, maybe let your audio catch up for a second and then restart this slide. I think it was getting a little fuzzy again.
Okay, so alternatives to conservatorship for marriage and social and sexual relationships. Can you hear me better? Yeah, okay. Marriage is a little simpler to control in a conservatorship because it's a contract, but controlling someone's friendships and sexual relationships is actually really difficult with a piece of paper. Education and training are much more effective ways to encourage good decisions, right? So some of the alternatives listed on this slide are services that you can get in an IPP. supported living services or independent living services, and things like counseling. You can also get education in the areas of social skills, safety awareness, how to have healthy relationships with other people. And that can include relationships with boyfriends and girlfriends. It can include information about marriage or preparation for marriage. So those are some of the alternatives that are available for that power. The other power that's a pretty big one in a conservatorship is determining where someone lives. That's, when you think about it, that's enormous, right? You make your own choice about where you live, and your values have a lot to do with that decision for you. So again, I've listed things that are available in the IPP process. And in case you don't know what supported living services or independent living services are, it's sort of a broad range of services that help adults with developmental disabilities. So in the context of a residence, you might have SLS services where someone, a vendor, a service provider comes to your house and helps you with things. They could help you select and move into a home, like the process of moving. They can help you choosing your housemates if you're going to have some. They can help you with buying furnishings, sort of common daily living activities, how to react in an emergency at your house. They can help you become a participating member of your community. So supported living services and independent living services are supposed to help people exercise choice and control in their daily lives. And one of the big ones in that topic is where you're going to live and who you're going to live with. So, typically a supported living service agency works with the person to establish and maintain an independent life in their own home. It's also possible for some people to supervise their services themselves. Independent living services are vendored and monitored by regional centers and focus more on functional skills, training for adults who have acquired basic self-help skills, but who might need more help developing those skills or using aids to help them in their personal needs. And another alternative is your circle of support. So that's your friends and your family to help you figure out where you might want to live. So those are all of the powers and alternatives that we went through. Let me look in the Q&A. Let's see. I'm going to read this out and try to answer it. If a youth is conserved, will the conservator have to go with the conservatee to medical appointments? Also, can a conservator enroll in classes at community colleges without consent? What is the difference with conservatorship and power of attorney? Okay, so I hope I answered part of that, right? The conservatorship is a court order that gives someone the right to make decisions for you, whereas a power of attorney is you deciding who's going to help you make those decisions or make those decisions for you instead of the court deciding. If someone is subject to a limited conservatorship, well, I'll say for every type of conservatorship, no one has to go with them to their medical appointments. There are different powers in different kinds of conservatorships. So in a limited conservatorship, the conservator can have the power to consent to medical treatment. That doesn't necessarily mean they have to go to their appointments with them. It depends on what the appointments are, what the medical treatment might be, what kind of documentation the doctor might require. And yeah, if someone's subject to a limited conservatorship and the conservator doesn't have their right to make educational decisions, then the person can enroll in classes without someone else's consent. If the conservator has the right to make educational decision-making, it's a little trickier, but ideally, if someone is conserved, especially in a limited conservatorship, the conservator has the obligation and duty to work with them to determine what their interests are and to help them develop skills to support their interests. So I see questions about a durable power of attorney and notarization. Yeah, so there were a few slides about that. A durable power of attorney for financial matters does require notarization. Some for different matters just require witnesses. So you really have to get the form and see what it requires. And to get something notarized, you just contact a notary who reviews people's IDs. A notary isn't reviewing a power of attorney for the substance of it. They're just making sure that everyone who's signed it is who they say they are. And then someone has written, it seems a catch-22 if the person needs a power of attorney for healthcare and finance, but they really wouldn't understand the contract they're entering into. What is a parent to do then? Yes, I agree with you, Pam. It is a catch-22. And so alternatives aren't always appropriate. In order to have an alternative that depends on someone having capacity to enter into a contract, they have to already have that capacity. So there are some situations where you might have to have a conservatorship in order to make some decisions. I would say it should be as limited as possible. And I see, how about the child isn't an adult, but has the developmental capability of a kid. How does that child know to do the power of attorney? Yeah, that's sort of the same question, right? So it involves a determination of someone's capacity, which if they're a regional center client, the regional center should be able to weigh in on to say, I see strengths in these areas, challenges in these areas. We might recommend this person needs a limited conservatorship for this specific area. But it really should be a review of someone's specific situation and needs. And then I see the question, do you need to file with the court? And I'm not sure
This
what
is in
that's.
regards to the durable power of attorney.
Oh yeah, no, you don't have to file a power of attorney with the court. It's an independent legal document. And the court doesn't enforce it unless there's a conflict, right, with whoever you've provided the power of attorney to. Okay, let me move on to this slide that I brought up. So I talked a lot about how conservatorship is. This slide has information about a new law that's being proposed to change the conservatorship system in some pretty significant ways. It's not the law yet. I just wanted to make you aware of it because some of the information in this presentation is going to be out of date if it passes. I also want to let you know that Disability Rights California is co-sponsoring this law along with other organizations like the State Council on Developmental Disabilities and Disability Voices United. What this law does is, see, there's 4 things that are listed there on the slide. It deflects. So that means really recognizing alternatives. It's a way of establishing supported decision-making in the law as a less restrictive option for people with disabilities. It would create what's called a technical assistance program to help people be trained on supported decision-making so they could know how to make it useful. It also diverts people from conservatorship by requiring that alternatives be tried and that the court examine them before establishing a conservatorship, and also that the court assess a person's capacity with supports that are available, not just in isolation, not saying, hey, you're on your own, do you have the capacity to make this decision, but saying, hey, if you had this person supporting you, would you have the capacity to make the decision? The other thing that the law does, we wrote there, dissolve. I said earlier, it's hard to end a conservatorship. So this would make ending conservatorships easier by giving people sort of plain language information so they understand their rights, and requiring the court to always appoint an attorney and have a hearing if someone wants to get out of their conservatorship. And also allowing courts to end conservatorships without a hearing if everyone agrees about it. Sometimes conservators say, oh, this was too much. We didn't know, we don't need to do all this. But then you still have to pay a lawyer to file a petition with the court and have a hearing, even if everyone agrees it shouldn't exist anymore. So this law would change that to allow the court to end a conservatorship if everyone's in agreement. And then finally, decide. The law sort of ensures people have the choice. It would require conservators to make decisions that are aligned with the person's communicated wishes, not just in their best interest, but in their expressed interest. And it also has a provision that would sort of what we call order of preference for conservators. So if someone is going to be conserved, there would be an order to say, this is the first person we should look to, right? Family members first, and then other trusted individuals, and then unrelated parties, because sometimes the court might just appoint someone who's not connected at all. And we really want to move away from that, because we think people who are most involved in circles of support and relatives usually know the most about someone and are more motivated to help them exercise their own choices than to just make their decisions for them.
Shannon, we had 2 additional questions pop up in the Q&A. I can read them out for you. So,
Sure.
Is the conservator legally responsible for the actions of the conservatee?
So no. Just because you've conserved someone does not mean that you are accepting legal liability for their actions.
Okay. The next question is, in a conservatorship, can there be a primary and co-conservator, 2 different people?
Yes. You can have a single conservator, or you can have a co-conservator. And I think it's more common in a limited conservatorship to make sure that you have a co-conservator, because if a conservator dies, the conservatorship terminates. And so one way to avoid having a lot of bureaucracy in that situation is to have a co-conservator who would still be around, and the conservatorship would not terminate.
And then a question about AB 1663. So, what effect would AB 1663 have on existing limited conservatorships?
Yeah, that's a good question. And I'm not super familiar with every nuance of the language of the law. I think in general, on an existing limited conservatorship, the change would be that if the legislature passed it and also fully funded it, the court would be reviewing existing conservatorships more often than they do now. Right now, they are supposed to review them, and that means have the court investigator contact everyone and see how things are going and if anything's changed. They are supposed to do that periodically, but it hasn't been funded, which means there's not enough staff in the court system to undertake all of those activities. So in reality, it actually doesn't happen right now. So I think the effect would be to have those reviews happen more often, which might mean the court would, call a hearing and have people come in and say, is this conservatorship working? Is there anything that should be changed? Do you want to dissolve it or change conservators? I think the likelihood that that will get fully funded immediately is pretty low, but that's the intent of the legislation, just to make sure that there are touch points for people to see if a conservatorship is still the best way to support them.
Those are all the questions we have for now, but just as a reminder for folks, we have a few more slides to go through. So if you have questions, please enter them in the Q&A now, and we can answer them before the end of the presentation.
Thank you, Stephanie. Yeah, so these are our last few slides, which again, you'll get copies of, so you don't have to copy this down right now. It's another link to DVU's supported decision-making handbook. I've also put in a link to Disability Rights California's publication on limited conservatorships and alternatives. And then there is a link to the form for assigning educational decision-making authority. That's, it's available on our public website. We have a publication called the Special Education Rights and Responsibilities Manual. And so there are some forms there that are helpful if someone wants to assign their rights. And then this is our contact information for regional center clients or family members of regional center clients. We ask people to call our local office. And for this area, that is Stephanie's office. So that's their contact information. The address is actually in the same building as the San Andreas Regional Center, but it's on a different floor. If you've ever been to their facility in South San Jose, that's where they're located. Although we are working remotely at present. If you do contact our office, and it can be about conservatorship or it can be about any issue for a regional center client, our staff will ask, what's the issue that you are calling about? They'll ask questions to determine how they can best help. They will ask basic questions like your phone number, your address, your birthday. And then I also want to let you know that the person with the disability is our client. So if you're the parent of a minor, we can work with you. We would probably, depending on how old your child is, want to speak to them to explore their wishes as well, particularly when people are older teenagers. If you're the parent of an adult who is a regional center client, we would need your adult child's permission to work with you. And that's the case even if you are their conservator. Because we work for the expressed interests of our client. So, and sometimes that's as simple as just having a three-way phone call where we explain what our office does and ask if, you know, they want our help and if they want us to work with someone else to help them. I do see we have a few other Q&As. I don't know about the recording. I think we'll let Claudia or someone else from PHP answer that later. A supported decision-making agreement. So the question is a supported decision-making form a legal document, and does it need to be notarized? So the answer is right now, there's nothing in California law that recognizes supported decision-making one way or another. So the way people use supported decision-making now varies in a lot of different ways. It might be informal, or you can have a formal agreement that says, I want this person to help me with this thing, and they've agreed to help me. That makes it a contract. But there are no formal requirements about notarization or format or anything like that. It's pretty flexible right now. And then there's another question that says, you probably talked about the power of attorney, but can you explain more? You know, a power of attorney just really varies depending on what the subject matter is. If it's financial, if it's medical, a durable power of attorney for healthcare. So, you know, we don't provide advice to people on those documents unless it's the person with the disability who wants the advice or they want us to give it to someone else. So I would just say, if you have a loved one and you're contemplating these different options, contact our office so we can get more specific information to you about a specific situation. And then we also have contact information if there's people watching or joining us who are involved with this person with a disability who is not a regional center client. You don't have to contact the Office of Clients' Rights Advocacy, but you can contact Disability Rights California. So I put our 800 number there, and when the intake line is staffed, it's staffed from 9 a.m. to 3 p.m. on weekdays, except for Wednesdays. If you call outside of that period, you'll leave a voicemail message and someone will call you back on the next business day.
And just to clarify, because Shannon did break up for a second, as the slide says, if your client, if your family member or the individual is not a regional center client, this is the direct DRC intake line for those who do have disabilities and may want additional assistance. So,
thank you, Stephanie. And then the very last slide has our direct contact information. If you want to call or email me or email Stephanie, it's available to you. And also our link to Disability Rights California's website with our publications.
Thank you.
And I think that's it. I would like to put in the Q&A or the chat in a way that people can access it, the link to our survey
I have it in the chat, and I'm gonna
Perfect.
hit now. And I also going to send an email along with information with the survey.
Perfect. Thank you.
So if you are not able to answer it, or you cannot see it, or you have problems, if you are on your mobile device and you have problems seeing the survey, you will have it via email next week anyway, or at the end of the session if it's that gonna work better for the Office of the Client Rights. I do have also a survey for you, and I'm gonna launch it. You can see it on your screen, and this is to report to our funder, the Department of Developmental Services. So we will be allowed to do more of this type of workshops, and they want to know how good we've been doing, if this information was helpful or not, and we can put more workshops for this type of information together for you. So I do have a question, and it was not clear to me, is in the part of you talk about the alternative and the contracts. On the part of the SSI, you mentioned that the Social Security will assign a payee, someone who's going to be in the contract. It cannot be any family member, it has to be someone determined by them.
No, it can be a family member. Yeah. Yeah, the representative payee for Social Security can be a family member, it can be a friend, or it might be an organization if no one else is available who qualifies. You have to have, there are certain qualifications to be a representative payee because you're being entrusted with someone's finances.
Okay, okay, that sounds good. And I'm going to ask again, please answer that survey. We have only 23 answers out of 35. So please go ahead, keep on present information, the numbers that you prefer. And we have one more question. Oh, this says representative PE. Thank you. Corrected me. Thanks so much. Yeah. And the last comment, I didn't consult my son, and I'm using that type of documents that you were mentioned, and it worked so far so good. And each of the medical offices, or for example, on my case, it's Kaiser, they do have their own documents. So they send you the documents, you go and sign the documents, so they will allow you to speak with the doctor, and the doctor will have to talk with you, and you can have access to the record. So it's possibly is any work is possible to do it, and work with it. Yeah, and
We had two more questions pop up in the Q&A just really quickly.
Go
that
ahead.
I can read out for you. So I have a 16-year-old who is non-speaking, lives in a group home, and is a SART client. If I don't do the conservatorship process, will my child be able to stay in the group home after age 18?
Yeah, that's a really specific question that depends on different variables. So I don't want to give an answer to that, live. I would encourage you to call our office, but also, in general, there's no reason an unconserved person can't live in a group home if they want to live in a group home.
Okay, and then the next one is another one that's a little case specific, but my 12-year-old daughter is currently a regional center client. Once she turns 18, if we do not have a conservatorship, will a regional center still be communicating with parents, or will my daughter be the one that has to contact them directly?
So it just depends on it depends on what your daughter wants. So when she turns 18, she can say to the regional center, copy my parents on everything, or ask my parents everything. I still want them making my decisions. And she can sign a document to that effect that the regional center will respect.
And the last one was, which again may not be something we can help with, but if we could send links regarding durable power of attorney for healthcare and finance. But again, I think that's something you would need to contact our office if you need help or the client needs help, so we can move forward with that.
Yeah, agreed. Okay, is that the last one?
Shannon and Stephanie. if there's no more questions, I guess we are done for today. I really appreciate the time that you took to participate this morning and share very valuable information with us. It's really important. Our kids are growing. We don't realize it when suddenly they are 18 and then we are being told by doctors, no, I cannot talk to you because he's already 18. Oh, the school gave us a document to sign for them to sign. And so we're going to be able to do or make decisions on their behalf. This is really important information. Thank you so much. I hope everybody got what they needed and get the questions answered. They were very clear and was fantastic. Thank you for being with us this morning. And have a wonderful, wonderful weekend, everybody. And we'll see you next time.
Thank
You to
you.
the
Thank you, everyone.
before we leave, I forgot again. Thank you to our interpreters, Q, Jordy, and John. You guys are always, and Anna, you're always supporting us and doing an amazing job behind the scene, helping our Vietnamese and Spanish community. Thank you so much to all, and have a wonderful weekend.